The only people who don't want to disclose the truth are people with something to hide.
And this is the time set for oral argument in Lamb versus Obama. Are you ready to proceed, sir?
Yes.
You may proceed.
Good morning, Chief Justice. May it please the court, for the record, my name is Thomas Lamb, pro se. And the issue, first issue that we're discussing is the issue of whether President Obama had been served. The Superior Court, Judge Piffner, basically held to a strict line on the Alaska Civil Rule where if it was sent restricted delivery, something was sent restricted delivery to the recipient, that he held that the recipient had to actually sign for the document. Security measures and federal law preclude the president from actually signing any documentation such as the return receipt. The process, as outlined in brief, showed the federal law that the regulation that pertains to as if the manner which is the agency of the White House, they have their own protocol, and if it is such that they designate that it's going to be stamped for security reasons, because when you call, they will not divulge any information about who signs for it. It's very hard to get information as far as getting past security measures, and one of those measures is that the documents were actually mailed to a facility where it's anthrax or checked for anthrax and other things as far as security, and then it goes to the White House. I called the White House office or the mailroom. They wouldn't even give me the information on that. So it's very difficult to find out who can sign from what on those receipts, but it was returned. And so I'm arguing that under the federal guidelines that basically the post office sent the letter or delivered the mail. They delivered under the law of as far as the regulations. So I'm just arguing that basically Judge Piffner erred, that he didn't consider the fact that there's certain protocols that are in line, security measures, and that it's impossible to serve the president personally, any type of through, I called the Capitol Police, I called the Secret Service, and then I tried to deliver it to the House. Secret Service indicated to the server that an affidavit is in the excerpts of record that it was to be mailed. So that's what I did. I sent it, restricted delivery to the president, and then it came back. So that, I feel, is that Judge Piffner has erred and is abusing his discretion in that part. The part on the issue of mootness, this whole case revolves around the public's right to know. This isn't a case, as outlined or suggested by Judge Piffner, that it's a birther case. There is no argument that the president was born in Kenya, and I want to make that clear. What the issue is if it's just pertained on records. There's some things that have transpired after the brief here. One is that we found out that President Obama indicated he never stayed with his uncle when he went to Harvard. That turned out to be a falsehood because during the immigration proceedings, that came out from the uncle. The other issue is, in other proceedings, the State Department misrepresented to the court in other cases, which we'll just label as birther cases, where they stated that the president didn't hold a dual citizenship.
Mr. Glenn, let me ask you a question. I think you prefaced this part of your argument with saying that this involves the public's right to know. So is the basis of your complaint that you're suing on behalf of the public? And if so, how do you have standing?
Standing the issue is, and this was brought up, is that there's been multiple cases of where it was the media that went and sued, meaning that in the Jack Ryan brace, he was sued for his divorce records. And it was always the media that went about this. Well, in the Alaska Dispatch, in their brief, they stated specifically that it was bringing the case, Alaska Dispatch, to the court, and when the Joe Miller case, is that what they did was they prefaced in their complaint that it was the public's right to know.
Okay, but those are all records that were, here in Alaska and held by a government agency. What records in Alaska are you seeking? Are you seeking his personal records or records in Hawaii, records in other places?
The college records specifically.
Are they here in Alaska?
They aren't here in Alaska, but the issue is that this is a national election. So the Superior Court has standing to issue an order because the federal law allows that. So if, let's say, someone was in Alaska here and they needed documentation from a college in another state, they would have that right to seek the records of that person. Same thing with the birth certificate. Assistant Attorney Jill Nagami had responded back to my inquiry to seek verification on whether there was an adoption or amended birth certificate, because records all indicate that there was an amended birth certificate. What the problem is that there's a going back and forth between, let's say there's a paternity case here in Alaska and it's a Hawaiian birth certificate. Does that mean just because the birth certificate is in Hawaii that the person here doesn't have let's say pro se, it's family law, deals with that, and you have a pro se litigant. Does that mean the pro se litigant doesn't have the right to seek verification on that? What we're dealing with is, in the case law, it's always dealing with the public official, is that we're affected. Everybody here in Alaska is affected by decisions by the president, by the executive. So we have a citizen taxpayer standing on that issue, and we have the right by statute to understand if the person is the candidate is qualified, and if there's a means that's outside the state that comes up and it states that this candidate may not be qualified, then we have a right to know that because that person is actually on the ballot in Alaska. It's not something that's far away from us. It's intimate with us. We have an intimate relationship.
So do you think that we have the right in Alaska then to anybody who's on the ballot, including maybe even a judge who's up for retention, any citizen of the state of Alaska or anywhere, I suppose, could sue that person and demand personal information?
Well, we elect all of you to the bench and to this court. So it depends on how much you want latitude. I mean, if there was just recently in the news
in the next governor's election, could you sue, assuming that Governor Parnell runs for re-election, could you sue Governor Parnell and ask for his personal records?
If there is something in there that justifies that, if something justifies that, I should be able to. If the media doesn't do that, because the media doesn't really always represent the voter, and it's always they may have their own agenda, and then one segment of society gets left out. It's just like, when I originally started this, it was Governor Romney was part of this suit because there was issues with the IRS. That's important, whether he paid. People have a right to know this. It's just like what happened with Twitter with, the name escapes me, Weiner, Representative Weiner. These are issues that are important, evidently, to the people because he's no longer the representative. He was going to run for mayor. He lost. So I'm not sure where you're trying to go with this, but it's always been that even in the state of Alaska, even though that the person, the case law deals with, someone in Alaska, does the person that we're seeking, or I'm seeking information, does he have an effect on us here in Alaska? Yes, he does. The other issue is as far as Judge Piffner, he had brought up the issue of jurisdiction. The courts have raised this issue. Now, there's a statute, the state statute allows a candidate, doesn't say presidential candidate, doesn't signify that. We have statutory laws that state that there are certain guidelines that have to be met. Well, the Department of Divisions has the ability to check the qualifications on that individual. That was misplaced, I think, when he said, Article 2 Section 2, I think he said. But the courts have jurisdiction to find out if a candidate is qualified. Now, the one statute cited in brief, it doesn't indicate whether it's a presidential candidate. It doesn't indicate if it's a U.S. Senate candidate. Those are issues that were never resolved, were never clarified. But as it stands right now, that any candidate is liable to, come under the purview of the Department of Divisions, whether they're qualified or not. So I think that was an error on his part to say that the jurisdiction, courts don't have jurisdiction over that. He said it was a political question. I don't think it is a political question. It's a matter of, you have guidelines that have to be met. And even with independent presidential candidates, they've been removed by courts in other, like in California and other areas. The court in Indiana, excuse me, they, when it came to President Obama, they found out that fraud had been committed on the ballot for the primaries there. And they said, according to news accounts, that he wasn't, they may not have even made the ballot back in Indiana. So the jurisdiction issue is one where the courts can look at it through the eye of the statutes that we have in here in Alaska. The other issue was the moot issue. It's not moot. The issue of the college records have not been resolved. They haven't been divulged, and there's issues, serious issues there with that because of the issue where, everybody's saying he's an Indonesian citizen. Doesn't matter. That was when he was a child. The laws don't apply to that. It's what happened after when he went to Occidental. If he claimed that because there's an affidavit that suggests that he went to school as a college as a foreign student, Indonesian law does not allow dual citizenship. So if he claimed his Indonesian citizenship as an adult, he did two things. One, he committed fraud because the law, according at the time of Indonesian constitution, states that it would have to be one or the other. And so that's the other issue. Another issue that came up is the dual citizenship, where it was admitted by him that he held dual citizenship, Kenyan citizenship, and also the American citizenship until 1983. And that was divulged by their site, Stop the Smears. Now, the issue with that is, again, did he present himself as, a Kenyan, choose this Kenyan citizenship? That we don't know. And you can't say yes or no. The only way you're going to find out is through the college records to find out if the person who said that, who initiated through an affidavit, said that he was a foreign student is in fact true. So the other issue is how do you resolve the issue now if, let's say, this court or you decide and say the Superior Court, I can have access to records. The issue is it's foregone on the issue of this court. Any court can't do anything. They can't undo the election. But as a citizen, I can go and initiate a congressional inquiry if it's found that fraud had been committed. And so anyway, if fraud had been committed, I go to the Congress and I say, this is it. Now, everybody, as far as what they do, the electorate or the voters in this country, they can say, we want you to investigate this further. It's on the onus of the Congress now to do something. But I feel that I still have standing to seek those college records because, as it goes, I'm a citizen taxpayer. And it goes beyond the Alaska as far as those records to seek that because we are all affected by decisions. Obamacare, anything that happens that through this any decision. So as it stands, I feel that there's been quite a few errors that have been made on this, but I feel that the public has a right to know. The people in Alaska have a right to know what their president is doing or what he has done in his past, and that's the bottom line on that. And I'm not saying that he's not qualified at this point because the records would vet that out. And that is a serious issue because what he has done in the past as a college student may have affected something that he's done in the future as a president.
And you have 1 minute left, so you should take that time to wrap up, please.
That's basically it, Chief Justice. That's all I can say is that there's a strong argument for the public's right to know and the citizen taxpayer standing on that. So, okay.
Thank you very much, Mr. Lamb. We'll take this matter under advisement, and we'll be issuing a written decision at a later time.
Okay, thank you.
The only people who don't want to disclose the truth are people with something to hide.